Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, I am going to tell you the landmark judgment, a recent landmark judgment by the Honorable Supreme Court of India regarding same-sex marriage. Actually, I did not want to make a video because as elders, the two old or conservative people, we don't like such gay marriages or same-sex marriages, things like that. But still, when people ask me to make a video, because in their view or in view of majority of the people, it's a landmark judgment. What is this judgment? Basically, please remember, on 17th October 2023, while disposing the writ petition number 1011 by 2022, 5 judges bench, including Honorable Chief Justice of India, Honorable Justice Sanjay Kishan Kaul, Pamadikhantam Srinasimha, Hima Kohli and S.V. Bhatt, all of them, with a majority, that is wafer thin majority of 3:2, held that same-sex marriage cannot go into records. That means it's not a valid marriage. That's the main problem. Right, you can read the cases. Supriya Chakravarthy and Abhay Dong and others, almost 52 persons have filed the public interest litigations. Supriya Chakravarthy Vs Union of India 2023. Right. So, what is this case? How it has become a landmark judgment? If you go to the background, you have to know the case of Navtej Vs Union of India, decided on September 6th, 2018, where Honorable Supreme Court of India held that Section 377 of the Indian Penal Code is unconstitutional. Normally, you all know Section 370, the purpose of the object of framing Section 377 as a penal section is that the sexual intercourse should be in a proper way. You should not go against to the nature while performing the sex. If you do it, then definitely it will amount to Section 377 of the Indian Penal Code. But what is the same sex? There is a community called as LGBT, lesbians, gay, bisexuals and transgenders. LGBT community, so Nas Foundation case you might have heard. So they have been filing cases. What they say is they wanted to marry each other. They are called unqueers. They wanted to marry each other and their relationship should be accepted as a marriage. This is the problem. So, a male and another male can get married if they have the so-called unqueer quality. మన తెలుగులో కొద్దివాళ్ళు అంటుంటాం, లేకుంటే ఏది గే అంటుంటాం, ఇద్దరు మాట్లాడుతూ ఉంటాం. So, Section 377 in Navtej case, it is held to be unconstitutional. వాళ్ళు బతకనడే. భగవంతుడు మనలాగా మగ ఆడ సెక్స్ చేసుకునేటువంటి ఇది ఇవ్వలేదు వాళ్ళకి. They have got their own methods, but they are unnatural. అయినా సరే వాళ్ళు వదిలేసేయండి, 377 కాదు అని చెప్పి నవతేజ్ కేసు మనకు చెప్పి. సో వారు రెట్టించిన ఉత్సాహంతో now they are getting married and they are going for adoptions, they are going for surrogacy. So many things are there. But they wanted them to be legalized, legally accepted. This point is whether the marriage can be solemnized between transgender. This is the point. For this, please go to, first of all, let us discuss the Special Marriage Act 1954, Section 4C, I think. It clearly says the male should have completed 21 years and the female should have completed 18 years. That means the marriage should be between male and female, not between male and male. But in Hindu Marriage Act, if you go to section 5, marriage between two Hindus, that was written, of course. That's why I've been telling you, ex viceribus actus, that means read the statutes as a whole. At least read the section as a whole. So if you read the section as a whole, there it will be mentioned that the bridegroom should have attained the age of 21 years and the bride 18 years. That means male and female. So the marriage to be solemnized should be between male and female as per the Hindu Marriage Act, as per the Special Marriage Act, as per whatever law you think to be. Now what these people say, these unqueers, they say that, are we not equal before law? Article 14, yes, everybody is equal before law. Can't we marry each other? Why it is not recognized? Second, the problems will be there not only regarding marriage. Of course, luckily, the court is kind enough to enter or to enroll so-called third genders into so many government jobs by making them as third gender. Likewise, the point is, suppose if they want to adopt some children, if they want to go for surrogacy, if the transgender person retires, and what about the pension to the wife? When she is not a wife, she can't get the pension. So many problems are there. So therefore, they asked the court to allow the same-sex marriage. But of course, our Chief Justice of India is a minor judgment, but major judgment says it is for the state, it is for the legislature to make a law on this aspect. We can't make a law. This is voice of the Constitution, the difference between voice of the Constitution and voice of the conscience, as stated by Honorable Chief Justice of India. We have to abide by the Constitution. The Constitution has given the powers to the legislature to make the law. So they have recommended to the state to make a law, to form a committee and make a law. But the important point in this case is, yes, the couple can live together, live in relationship, that can't be denied, but marriage cannot be solemnized unless there is a specific law. Adoption cannot be solemnized unless adoption cannot be recognized unless there is a specific law. So the Honorable Supreme Court said it is for the legislature to make a law, but legislature, the central government, vehemently objected for the so-called same-sex marriages. So we don't know what will happen, but anyway, this is the story behind. So please remember Supriya Chakravarthy case, Navtej case, section 5 of the Hindu Marriage Act and section 4 of the Special Marriage Act, and then analyze the case critically. You will definitely you will appreciate what I tell you, and your legal knowledge will be definitely enriched. With this, I am concluding. Thank you very much.